Good evening. Thank you for joining us for the Delaware County Property Reassessment Impact to Taxpayers webinar. We have some fabulous panelists with us today to talk about this issue. And I'd like to first start off by giving an overview of who our panelists are. We have with us today Michael V. Pupio. Mr. Pupio is the founding partner of Raphael Pupio, one of the largest full-service law firms in Delaware County. He concentrates in the areas of education law, municipal finance, and litigation. He is a solicitor for many school districts and municipalities throughout southeastern Pennsylvania, including the Delaware County Intermediate Unit, Garnet Valley, Penn-Dalco, Interborough School Districts, Chester Community Charter School, Glen Olden Borough, Ridley Park Borough, and the Zoning Hearing Board of Collingdale. He also serves as special counsel for the Upper Providence Borough, Upper Darby School District, Southeast Elko School District, and Springfield School District. Also with us this evening is Mark A. Serini. Mr. Serini is also a Delaware County attorney whose law firm is in media. He has served as Delaware County School District Solicitor for over 30 years and is currently the solicitor for Marple Newtown and Springfield School Districts. Mr. Serini enjoys a wealth of litigation and courtroom experience, having represented school district in real estate tax appeal cases all the way up to the Pennsylvania Supreme Court. He currently serves as the president of the Delaware County Trials Lawyers Association. Also with us tonight is Mr. Don Mooney. Mr. Mooney has served as the Executive Director of Operations for the Springfield School District in Delaware County since March of 2009. His current role includes the oversight and management of the non-educational functions for the district, including the finances, facilities, technology, human resources, and athletics. He also works with the board of directors and the superintendent on strategic planning and collaborates on developing the vision and mission for the district. Also with us is Matthew Bilker. Mr. Bilker is an associate in the litigation department of Eccles Sparks in Media, Pennsylvania, where he focuses on personal injury litigation, general civil litigation, and municipal law. He joined Eccles Sparks in September of 2013 after finishing a judicial clerkship with the Honorable John P. Capozzi Sr. in the Delaware Courts of Common Pleas. He formerly served as an assistant county solicitor in Delaware County's Office of the Solicitor and currently serves as solicitor for the Marple Township Zoning Hearing Board. Mr. Bilker also is on the Board of School Directors for the Marple Newtown School District, where he was elected president by his colleagues. And to round off the panel, we have Mr. Greg Chestnut. Mr. Chestnut is a retired management consultant, having spent 17 years at Anderson Consulting. Since his retirement, he has been actively involved in the community he serves. He has been a Garnet Valley School District Board of Directors since 2013 and is currently the chair of the Finance Committee. He was on the Board of Trustees as the Rachel Cole Community Library from 2007 to 2020, where he served as past treasurer and president. His community service also includes treasurer of Cub Scout PAX 260 from 2009 to 2017, and treasurer and committee chair of the Boy Scouts Troops 154 from 2013 to the present. We have an exciting agenda here today. And the first to talk about what is a reassessment and why is it done? Mr. Pupio, can I turn this over to you?
Certainly. Thank you, Dr. Edelberg, and good evening, everyone. It is my pleasure to be here to assist and to provide some information that I'm sure others will echo here on this panel with regard to assessment, reassessment, and the current state of affairs in Delaware County as it pertains to those items. I guess the first topic to discuss is, what is an assessment? What does it do? What does it mean for taxpayers, for school districts, and for other entities? So an assessment is a value number that is statutorily supposed to be arrived at either by cost, income, or simply an arm's length transaction of a property. And that is the value that the county assessment office places on each folio that is placed into the record, identifying what the value of that property is, or what the assessment of that property is. That number is then used by at least three entities: Delaware County itself, your municipality or your home borough, and then your school district, to determine the rate of taxation that is applied to that assessment. That rate of taxation applied should equal your property taxes to that entity based upon your assessment individually. So this is a number that impacts every property owner, including those individuals who do not have, who are not for-profit entities. For example, hospitals or areas of charitable care also have an assessment that is placed upon them, because their designation as a charitable institution is different than the designation of what the assessment is. So a non-tax-paying entity such as a University of Penn will have an assessment placed upon their property, because in the event the University of Penn sells that property, or it should be determined somewhere down the line that that property is not a charitable entity as described under the laws of Pennsylvania, then that property will then be subject to taxation, and the assessment will be the number that is utilized for that. So in a long-winded way of saying it, every folio number has an assessment that is placed on it by the county assessment office, that taxing entities then utilize to determine what everybody's individual tax is. Reassessments. Reassessments can take place in any number of ways, but in Pennsylvania and in Delaware County, they have only taken place in one fashion, and that is a court-ordered reassessment. Reassessments can be ordered by the Board of Assessment Appeals themselves, and then subsequently affirmed by the county, depending upon the specific class of the county in the Commonwealth of Pennsylvania. But for the most part, reassessments take place when a property owner feels as though they are aggrieved and they believe that they are not uniformly taxed throughout the county as compared to other taxpayers. So they will bring a grievance to the Court of Common Pleas in media, alleging any number of things, including, but mainly, that they are not being taxed in a uniform fashion. The taxpayer is not taxed the same as every other taxpayer in their circumstance within that district, and therefore there should be a reassessment. There were up until 20 years ago, there was no identifiable reassessment that took place in all of Delaware County's history. And up until that period of time, we now have two court-ordered reassessments. One took place, the court order case took place in 1996. The reassessment was ordered to be effective 1/1/2000. And then the current reassessment that we are undergoing, that lawsuit took place in 2016, and the current reassessment is supposed to be effective 1/1/2021. So what happens in a reassessment? What happens in a reassessment is that the county is required to place a new value on every parcel of property, every folio number that exists in the county. And their method at arriving at that number generally varies, but it has to be within a certain statutory requirement. Mass appraisals or a mass appraisal system where algorithms are used are permitted. It is permitted, and that is something that does go on in terms of determining the values. So the county in 1996, and I would assume sometime in 2016 or 17, hired a reassessment company. That company is Tyler Technologies. Tyler Technologies will then take a look at the task that was assigned to them, which in this case was a reassessment of all properties in Delaware County. And they will then subsequently go about that reassessment, that task in some different ways. As it related to residential properties, they sent out some surveys. They gathered some data specifically from property owners for data checkpoints, square footage, number of bedrooms, basement, attic, additions, that type of stuff. That was a different process than Tyler used to determine commercial property and the values of commercial properties. And from everything that we can see, it appears that different data was submitted into a mass appraisal program for commercial properties that then vetted a specific number. So the county was required by a court order in 2016 to undergo a reassessment. They set forth the parties to that case, set forth an agreed upon timeline. That agreed upon timeline is the one that we are under right now, with these properties coming in for a final value in January of 2021. What was the previous value? The previous timeline was for the county to produce preliminary numbers in the spring of this year, allow taxpayers in a reassessment year. There is a permitted preview to taxpayers of an assessment of saying, we believe this is your number. You can then reach out to us, Tyler Technologies, informally. School district is not a part of that proceeding. The county is not a part of that proceeding, to say, A, we think you got it wrong, Tyler, and here's why, or B, here's additional information that you, Tyler, may not have had about our property in your calculations. So, those calls are never for increasing assessments. They are always for decreasing assessments. And then Tyler then has an opportunity to make a change to that number informally and present formal numbers to school districts and taxpayers, which took place in July of 2020 this year. And school districts and taxpayers had until September 30th of this year to file for those appeals. Those appeals that were filed are currently being heard by a panel of Board of Assessment members, a regular board, and then supplemental boards that have been appointed by county council pursuant to the statute pertaining to reassessment and authorized by county council. That is supposed to finish up and those numbers to be certified officially on December 1st of this year, which would then provide for parties to take either the school district or the taxpayer to file an appeal to the Court of Common Pleas. So that is just a little bit about assessment and some reassessment. I'm not sure where I am on my timeline or anything along those lines, but I know that we're missing a panelist or two, so I'm sure we're going to fill in where appropriate. So Mark, I believe I would turn this this discussion over to you to discuss Board of Assessment appeals and then subsequent Common Pleas appeals.
Yes, thank you, Mike. I'll begin by building upon the foundation that Mike just laid. And to recap a little bit, if you own taxable real estate in Delaware County, then you are required to pay real estate taxes to three separate local governmental agencies, which is their primary source of funding. The first is Delaware County, which is governed by Delaware County Council. The second is your particular school district, which is governed by your school board. And the third is your municipality, your township or your borough, which is governed by your local governing body. We call those three local governmental agencies the taxing authorities. And you pay your real estate taxes to each taxing authority according to a formula that Mike referred to. As he explained, your property has assigned to it, one way or the other, an assessment. That's a certain value that's assigned to it. And then the taxing authority, remember there are three, each year approve a certain millage rate. Although the assessment is the same for your property, you have only one assessment. Your millage rate differs depending upon whether you're paying the taxes to the school district, to the county, or to the municipality. So you have one assessment value, but you have three different millage rates. And that determines how much you pay in taxes to the respective taxing authorities. You multiply the assessment by the millage rate, and that determines the amount of taxes you have to pay to each of those taxing authorities. Now, the taxing authorities do not set their millage rate until a certain time. So a very common question is, how much am I going to be paying in taxes for this year, for this upcoming year, 2021? And the answer is, it's too early to tell, because the taxing authorities have not yet had to set their millage rates. All that is known right now is what assessment has been assigned to your property. And as Mike alluded to, there are certain things that you may be able to do about that assessment, which I'm going to shift to next. Just please keep in mind that the largest millage rate is always the school district's rate, because that's the biggest governmental agency in terms of the largest amount of resources needed to provide the public education to our students and families. So depending upon the given circumstances, there can be three different types of appeals to challenge your assessment on your property. One is referred to as the annual appeal. That's the kind of appeal that you have when it's not a countywide reassessment year. That it's important you know that, because even if you did not file an appeal challenging your countywide reassessment number, you can file next year an annual appeal. It's typically by August 1st of the year, so it'll be August 1st, 2021, to challenge your assessment for the 2022 year. So even if you miss that deadline to appeal your countywide reassessment number, which Mike said was September 1st of this year, which has already gone by, you can address or attempt to address your assessment for the following year through what's called an annual appeal. And that deadline is most likely going to be August 1st of 2021. So that's 9 months away or so. The second type of appeal is an appeal from the countywide reassessment. I'll go back to that shortly. And the third type of appeal is an appeal that does not matter whether it's a countywide reassessment year or otherwise an annual appeal type of year. And that's referred to as an interim appeal. If your property, God forbid, suffers a fire loss, or on the other hand, you completed significant renovation to the property, that your assessment will be adjusted based on that. By the way, your assessment is not automatically adjusted if you sell your property. Unlike something like a fire loss or a significant renovation, which we call triggering events, selling your property does not automatically trigger the tax assessment office to put a new assessment on your property. And by the way, what I'm trying to do is work in answers to questions that we received earlier and try to address them as I reach them. Then as far as the countywide reassessment appeals, as we explained, the deadline has already come and gone. But if you did file by September 1st, as Mike explained, you either have been in front of the Board of Assessment Appeals or will be about to. Our information is that over 10,000 appeals were filed by property owners. And the taxing authorities also have the right to appeal. And there have been about 1,250, from what I understand, filed by the taxing authorities. Almost all school districts, I think all school districts have filed those because, again, the school districts have the biggest stake. The hearings before the board, if you've went through them, they're short. They're not necessarily sweet, but they're short. And they're still going on. In fact, our expert appraiser was going to participate in this panel discussion, but he is actually stuck in front of the Board of Assessment Appeals as an expert because he has gone, those appeals have gone over much later than what was originally scheduled. I'll wrap up by just explaining what's left in the process. We understand that November 15 is the deadline by which time the Board of Assessment Appeals is supposed to send out notices of its decisions. But we're also told informally that everyone should expect to get in the mail their decisions towards the end of November. But if you wish to take the next step and challenge the decision made by the Board of Assessment Appeals, you have the right to do that. You can file an appeal with the Court of Common Pleas in Delaware County, Rate and Media. Similarly, the taxing authorities have that same right. But you have only 30 days from the date that the board has issued its decision. So to be safe, you should go by the date that is on the notice from the Board of Assessment Appeals and not the date that you received the decision in the mail. So it may very well be, based on past practice, the date may be November 15 on your notice, but you may not receive it in the mail until 2 weeks later. If you feel that you need to consider an appeal to the Court of Common Pleas, you should track your deadline as 30 days from the date of the notice so that you protect your appeal right instead of being too late to file your appeal. The appeal filing fee at the Court of Common Pleas level is approximately $300. You do not have to have an attorney. If you choose to have an attorney, although I'm not giving legal advice, obviously, I can tell you that there are well-qualified attorneys out there who will represent property owners on a contingent fee basis, meaning will not charge by the hour and instead will charge a fee based upon what they save the property owner in taxes. So that concludes my part of this presentation. I do not believe that our expert, Jack Coyle, has been able to rejoin us. So I'm now going to turn the presentation back to Mike Pupio. Thank you.
Dr. Edelberg, did you want to touch base with some of the other panelists in the program and then run through it, or how would you like to proceed?
Mr. Pupio, would you be able to maybe give just a quick summary or your understanding of where some of the kind of possibilities of challenges with this current assessment might be? And then our other panelists can help highlight what those challenges will look like.
Certainly. So as Mark mentioned, a reassessment year is a different year as it reflects and relates to the rights of all the parties involved. On an annual basis, every year, a property owner can appeal what they believe their assessment to be, either on a valuation standpoint, meaning I believe my property is worth less than the assessment, whatever that fair market value is, and or I believe that I'm not being taxed fairly, a uniformity challenge. A property owner can bring that appeal every year for those reasons and additional reasons. School districts and taxing entities such as boroughs and the county itself are restricted in the appeals that they can bring. So they are restricted either statutorily or by case law, so that school districts are prohibited from doing what is known as spot assessment. So using the folks that I'm looking at on this screen here, if the three of us are, if Mark, myself, and Dr. Edelberg all own one part of a 3 townhouse unit, and we were all assessed at $200,000. We all bought at the same time, and Mark sold his unit for $400,000. Prices were good, and it doubled. If Don, as the school district, Don is not able to say on an annual basis, I'm going to tax Mark because he sold his property and it's obviously worth more because he just sold it for $400,000. Therefore, it should be a doubling and the assessment should go up. That's what's known as spot assessment. That is not permitted under the laws of the Commonwealth of Pennsylvania. There has to be a reason or a plan on a school district's part that is court approved at some point, if challenged, to indicate that the school district move forward with appeals. On a reassessment year, everybody is on the same footing. The school district is on the same footing as a taxpayer, and each taxing entity is on the same footing as each other. So the school district can appeal everyone for any reason. And if you are a property owner and you own multiple parcels of property, you can appeal multiple parcels of property for whichever reason you want. That's the difference between a regular year and a reassessment year. As the data, and that's important because a lot of the questions, or at least a couple of questions I saw in the FAQ, had to do with uniformity in taxpayers, as taxpayers saying, how do I know if I can make a uniformity challenge if I don't know what everyone else is being taxed at? What is everyone else in my street? What is their assessment? How can I look that up before the deadline? So that's generally what a homeowner would want to do. They sort of would want to see what's going on in their neighborhood, in their townhouse complex, in order to see, am I being assessed fairly? School districts and taxing entities look to do the same thing. It is their gauge by which they need to measure whether or not a reassessment was done correctly or incorrectly. And it is not as if all of that data is immediately provided. There are questions as to how some of that data was provided to school districts in order for school districts to make that determination. In short and in summary, there are a number of school districts who have consulted with an expert, Jack Coyle, who was supposed to be with us this evening to elaborate a little bit more, and provided him with information as to what the values that the county placed on a school district's roles were for their assessment. And there are a number of school districts that believe that there are problems. They don't believe the county has properly placed a value on a countywide reassessment. Believe it may have been done improperly, not necessarily uniformly, outside of the coefficient of dispersion. Those are the types of arguments that could take place with school districts that feel as though the county has incorrectly conducted the reassessment. Those appeals have been brought before the Board of Assessment. A decision hasn't been rendered on them. I would hazard a guess that if anyone on this call were betting individuals, that it would probably be a very safe bet to indicate that the Board of Assessment is going to respond in one of two ways, either in a way that they don't have jurisdiction, that they are not the proper entity to determine whether the reassessment was done correctly, or they will decline that opportunity to overturn the reassessment and allow it to move forward to the Court of Common Pleas. If there are any districts, after they get all of their final numbers from the same as taxpayers, who will take a look at this and then make a determination as to whether or not they want to challenge their individual assessment, or whether they want to challenge the countywide reassessment. So things that could take place in the countywide reassessment are very simply, a large number of errors that taxing entities don't feel as though Tyler picked up on, missed properties, or general mistakes. Again, we're talking about a formula, a mass appraisal, that while not wanting to speak down to anybody, I'll tell you quite candidly, I don't understand it myself, nor are we privy at this point in time to the methodology that Tyler and the county used to arrive at these numbers. So those would be some of the grounds that as we move forward, that we would allege if there are school districts that feel as though there would be problems with the reassessment, Dr. Edelberg, those would be areas that we would allege.
Thank you, Mr. Pupio. And I think what we also have tonight is a couple school districts to sort of highlight what this reassessment might mean to taxpayers. First, we're going to hear from Mr. Mooney from the Springfield School District. Mr. Mooney, can I turn this over to you?
Thank you, Dr. Edelberg. Good evening, everyone. I appreciate the opportunity to present to everybody. As the panel discussed the agenda on what we talk about, we talked about whether we could give you some case studies here, and 3 districts tonight will provide you with their individual case study. I'm from Springfield School District, Greg Chestnut from Garnet Valley, and Matt Bilker from Marple. We're going to share with you kind of what we see under the preliminary values we received from the county and the Board of Assessment on what's happening with our district. And I'll talk a little bit about, for Springfield, what it means for some individual taxpayers within our community. So as Mark and Mike have told you, the county's been working on this reassessment process for quite a while. The values that Tyler was supposed to calculate were as of July 1st, 2019. So a good point to remember, that's all pre-COVID on where values stood as of July 1st, 2019. So what Springfield did is we did a right to know request, and we asked for our overall values for our entire population of parcels in both the Morton and Springfield communities. And we received the report from the Board of Assessment. We have about 10,500 parcels. The values were all provided, what the current assessed values are right now as of 2020, and then what the projected values as of July 1st, 2019, which Mark and Michael explained, will go into effect January 1st, 2021. So quickly, we took that data and started to analyze it. And we looked at it on a very high level at Springfield. And we said, where is the total values? What are we looking at here? And I'll go back to 2020. Our current assessed value is 1.8 billion, is what it is for the Springfield and Morton community, the school district of Springfield. When I totaled up the report that we received from Tyler and the Board of Assessment, the new values projected as of July 1st, 2019 of what they would use for January 1st, 2021 was 3.12 billion. So 172% increase in assessed value based on the new reassessed values that they put in place or are projected to put in place. Now remember, Mr. Serini already commented, there's over 10,000 appeals going on. These are projected values based prior to the appeals being started. So these numbers definitely are going to change. But I want to assure the taxpayers and anybody listening tonight, taxes don't go up 172% based on the assessed values going up. What the taxing authorities have to do is, this is where you have this conversation about revenue neutral, is what happens. We calculate our millage right now for 2020 at Springfield. Our current millage is 34.4827%. You'd apply that millage to your current assessed value and you come up with your taxes, your school taxes in our case. So under 3.12 billion, the new values, we have to back into the same taxes that we're collecting right now for 2020, which is $62.3 million what the district is collecting for 2020. So obviously we had the new total assessed value at 3.12 billion. We know what our taxes need to be, 62.3. We calculate what the new millage is going to be. And in Springfield's case, it would go down to 19.9921 is what our millage would go down to January in 2021. Now, when I apply those values to individual parcels, there are winners, losers, and people that stay the same when you go through that calculation. So when we looked at the overall assessed values, we started to analyze it by type of parcel. residential, commercial, industrial, ground. They're the taxable parcels, and we started to look at where those totals went to. So when I look at our values for 2020, residential value consisted 76.03% of our overall total assessment. Commercial properties equaled 22.9% of our overall value, and industrial and ground were all under 1%. When I looked at our new values projected for July 1st, 2019, I saw a shift in the assessed values. Residential went to 2.58 billion, which equated to 82.7% of the overall assessed value, up from 76.3%. Commercial values went to 501 million, and it went to 16.07% of our total value, where it was 22.9 under the old one. So when I applied that new millage to the overall parcels, we saw a $4.1 million shift in taxes from commercial properties to residential properties. And that equates to about 8.8%. If I did that over an average assessed value for residences, it would be an 8.8% increase in taxes. So as we dug deeper into the detail and we worked with Mr. Coyle and Mr. Sereni's firm to look at this, we identified parcels that we felt were undervalued. And there's 76 appeals that Springfield School District has filed for properties that we believe are undervalued under this new reassessment. And we'd like to challenge them under our hearing opportunities that we're going through right now. So when I look at individual taxpayers, I'm going to use simple numbers, $100,000 assessed value. So they would pay $3,448 under 2020 millage rates, 34.4827. When I look at their new value as of July 1st, 2019, their value is $203,720. So it's a 203% increase in their assessed value. But that doesn't mean their taxes go up 203%. When I look at their new tax calculation under the new millage, their taxes would be $4,073 projected. And that's a $625 increase in taxes from 2020 to 2021 based on what the reassessment has done. That's an 18.1%. That what I would call a loser under the situation that we're talking about. And I'll give you another value. Our median assessed value at $147,020. Under current assessment, it's $5,070 in taxes. That's our median value in our community. When I look at their new value, it would go up to $269,540, 183% increase in their assessed value. Their taxes do not go up that much. Their taxes go to $5,389, a $319 increase under the new projected values, which would equate to 6.3% increase, lower than the 8.8 overall average. And then finally, I'll call a higher assessed value in our community, $250,000 under 2020 assessed values. Their tax would be $8,621. When I look at their new value, it goes to $410,270, 164% increase in their value. Their new taxes would be $8,202, a decrease of $419 under the new projected values. I would label them one of the winners in this overall process. There's negative, middle ground, and winners, and that would be a winner, a decrease of $419. Let me just give an example of two commercial properties. A $10.1 million assessed value currently pays $348,000 in taxes under the 2020 millage. Their new value, $11,960,000, 118% increase in their assessed value. Their new tax is $239,106. Their taxes would go down $110,000. That is one of those issues that we're looking at as our district, that we believe there's been a shift in the commercial properties, that their values are undervalued on their new values as of July 1st, 2019. So you can see there's a lot to analyze in that file, 10,500 parcels that we're going through. And as we look at these changes, we do see the overall shift, which we believe is not correct. And we'd like to go into our appeal hearings and explain why they're not correct. Mr. Coyle and Mr. Sereni's firm will help us with that. And hopefully we get some changes on how it impacts our Springfield taxpayers. Why don't I turn it over to Matt Bilker, from Marple, and he can talk about Marple's case study.
Thanks, Don. Hi, folks. My name's Matt Bilker. I am the president of the Board of School Directors of the Marple Newtown School District. And as many of you already know, school directors are in charge of, amongst other things, setting district policies and collecting and approving annual budgets, which includes appropriating and collecting enough revenue to pay for the district's expenses. So I've listened to the discussions this evening, and I think that they provide a lot of good, thorough, concrete analysis. And you heard Mike, I think, mention some of the complex methodologies that are used to determine value for each property in the county. I look at this from a simpler lens. The reassessment isn't fair for residential property owners. Remember that this process didn't occur overnight. The county had been undergoing the reassessment process for years. And what we as school directors were advised by county representatives to tell our constituents is that the process would be revenue neutral. And that from a general standpoint, in any given town, a third of property assessments would go up, a third would stay the same, and a third would go down. We were told that the process would be fair and that properties were supposed to be assessed at what they could sell for. And after careful study, our district has concluded that the countywide reassessment is not accurate, it's not fair, and it's not equitable for our district and our taxpayers. So first, I'd like to give you a couple of concrete examples on the inaccuracy and this unfair and inequitable treatment. And then I'll show you the overall impact that this inaccurate and unfair treatment has had on our residential property owners. So for these examples, please keep in mind the term fair market value of the property means what a buyer is willing to pay a seller for the property. That's really the best measure of what a property should be assessed at. So for a commercial property in Marple Township, the countywide reassessments proposed a new fair market value is nearly $7.5 million lower than the selling price for which the property had recently sold. So this commercial property sold for nearly 7.5 million, more than what the assessment, the new reassessment, says it's worth. That amounts to a ton of tax dollars, right? Where do you think they're making up the difference to get to revenue neutrality? You guessed it, on the shoulders of residential property owners. For a commercial property in Newtown Township, the countywide reassessment proposed a new fair market value for that property of nearly $6 million lower than the selling price for which the property recently sold. So again, this commercial property recently sold for $6 million more than what the countywide reassessment says it's worth. Our study also focused on agreed upon fair market value from recent tax appeal litigation. For a commercial property in Newtown Township, the countywide reassessment's proposed new fair market value is $16 million lower than the fair market value that the owner had agreed to and that the court had approved in litigation months before, right? So ask yourselves how that can be a fair, for both of these scenarios, how can that be fair? We have an agreement between both sides here of what the value of a property is, and shortly thereafter, the countywide reassessment states that the property value is millions and millions and millions and millions of dollars less, right? Again, that all goes back on the residential property owner because all of their property values have been overassessed from a global perspective. Another commercial property in Newtown Township, this countywide reassessment proposed a new fair market value. It's almost $4 million lower than the fair market value of the owner real estate appraiser's agreement in existing litigation. If you ask yourselves, how can this be? The answer, of course, is that it can't and it shouldn't. So our study in Marple Newtown, it showed that more than 1,700 properties within our district whose proposed new countywide fair market value is 15% or more lower than either the current implied fair market value or a recent sales price for that property. Our district can't financially afford to appeal all of these proposed new assessments. That could have cost the district over $15 million, and those are tax dollars, and we couldn't do it. And so what we could afford to appeal was only 5% of those properties, which is less than 100. So the problem created by the countywide reassessment is so large that our district can't simply afford to appeal ourselves out of it. And as I've pointed out, and as you can see from the above examples, our district's residential property owners are bearing the brunt of this inaccuracy. Under the countywide reassessment, our district's residential property owners' burden would increase to 80.91% of the total real estate tax burden, which is a 2.43% increase of our district's residential property owners' burden. Without remedial action, that would mean that even if our school board somehow managed to be able to not raise taxes for the 2021 to 2022 school year, under the countywide reassessment, our district's residential property owners' tax bills for 2021 would nevertheless contain an automatic average 2.43% increase in real estate taxes for 2021. And what would the residential property owners get out of this increase? The answer is nothing new. At least when we need to increase revenue, we can point to increases in salaries, in benefits, infrastructure repairs, things that improve our school district. Here, people are paying more and not getting another darn thing, and it's not fair. Because the law requires a countywide reassessment to be revenue neutral for our district, our board would be powerless to stop that automatic average 2.43% increase without remedial action. So what remedial action, you might ask? And I think it's important to point out now that school districts in Delaware County, we want to work with officials in Delaware County. We believe there is a window to collaborate and work together for the collective good. And we remember all the constituents of Marple Newtown School District or Garnet Valley or Springfield or Radnor or Chester, Chichester, all of them are constituents of the county as well. And I don't see a reason why we can't all be on the same side here. And so it's our hope that we can work with the county to achieve equity and fairness. I'll leave you with this thought, because perhaps like many of you, when I was a kid and I would get projects assigned from school, I would spend time and hours working on the project. And then I'd show my dad. And my dad would say, "This isn't good enough." So what do? Do I turn it in? No, not in my house. I didn't turn it in. I got back to work to fix the problem. I fixed it because it wasn't good enough. And that's what we're asking here. This assessment, this whole process needs to be fixed because it's just not good enough. I guess with that, I'll hand it off to Mr. Chestnut from Garnet Valley.
Okay, thank you, Matt. As has been pointed out earlier, the folks that are on the call from the school districts have multiple responsibilities. One of them is to make sure that revenue is collected properly for the school district. But also we are elected by residents of our communities, and we are representatives of the taxpayer. So we take seriously the issue that things need to be done fairly for the taxpayer in a situation like this. If you had asked me 6 months ago what I knew about reassessment, it would be a total zero. But I have had to get smart fast, as many of you are and will have to in the near future. I want to share my screen for a second here to show you guys, all you people on the call, something you can do. So if I share my screen and I go out to the county's website for the Bureau of Assessment, they actually have and are required to publish all the reassessment numbers by municipality across the entire county. So you can click into your municipality and see what every property is currently assessed at and what it will be assessed at in the future. I happen to live in Chester Heights Borough. These are the numbers for Chester Heights Borough. See if I can make it bigger for you. And I'll just pick on the first person on the list there. Nancy and Scott Martyr, currently assessed at $280,000, moving to an assessment of $453,000. The question, of course, is that fair or is that not fair? That certainly can be under debate. But what you, the taxpayer, can do is take a look at these numbers. If you live in a development and you can look at the houses that are around you, are they getting assessed about what you're being assessed, or is there something different there? Is that current assessment that's being assigned to you, is that about what you think you can sell your house for? If not, there's something wrong there. When I personally went through the numbers for Chester Heights Borough, once again, I'm not a statistician, I'm not an appraiser, I'm not a real estate agent, I'm not a county official, but I quickly came across a couple of different things. First of all, in Chester Heights Borough, we don't have a lot of commercial property. It's very residential, but we do have some commercial property. We have a senior living facility that was built about 5 years ago. That property is currently assessed at $17.8 million. In the new assessment, it was assessed at $329,000. So that is money that disappeared. And on top of that, that same facility sold in June of this year for $45 million. So Whether it's a typo or whatever it is, there is $45 million in taxable base that has disappeared because of this reassessment. Where will that be made up? It will be the residential taxpayers that will make that up unless that problem is fixed. We have appealed that particular property and are appealing others. Another example that we have in Chester Heights Borough and Concord Township, we have a condominium complex that was built in 2007, where when I look at a chart like this, I can see that there are dozens of units that will have a over 20% decrease in value. And I find it hard to believe that that's happening in that particular complex. We think they're far more valuable. We're not quite sure what they did to come up with these numbers. So I would definitely encourage everyone to go to the county's website, take a look at the numbers. If you are so inclined, take this PDF document and convert it into an Excel document, and then do your own analysis of the numbers. That's certainly something that can be done. So then part of the reason for this call is, what do we do about all this? Well, this group that you see on the call, plus others, has been trying to reach out to county council over the last several months. In most cases, not very successfully. I did attend the county council meeting back on October 28th and raised the exact issues that we're talking about here. We think that there has been an unwarranted shift from commercial to residential taxpayers, and we think that the numbers are not uniform and therefore are incorrect. Our basic contention is this reassessment is not fair because it is not accurate. It cannot be fair if it's not accurate, and we believe it's not accurate. We have asked for a meeting with county council as a group to talk this through, because we'd rather not be in a position where we have to file hundreds, if not thousands, of appeals at taxpayers' expense to sue the county taxpayers at the taxpayers' expense to get this problem resolved. We think there are ways to do this without resorting to litigation, and that's what we're following up on. Just this afternoon, I did get a response from the chairman of county council, Brian Zidek, that he has agreed that a group of school districts, whoever they want to be, plus members of the county council and the members of the board assessment, can meet to talk about this topic. So that's a very good, big development. But we need public support for the people that are on this Zoom session to stay close to the issue. This is a big problem that will affect the taxpayers of this area. That's all I have for now. Thanks.
Thank you. Mr. Serini, would you like to kind of help to give some closing remarks for this panel presentation?
Certainly. As all of our speakers have highlighted, the responsibility to implement a fair and equitable countywide reassessment rests upon the county. The court ordered the County Board of Assessment Appeals to develop and implement this countywide reassessment. That is a core and critical function of county government to, if it's going to implement a countywide reassessment, to implement one that is fair and equitable. You can look at the county's website, and it acknowledges that is its responsibility to implement a fair, equitable, and transparent countywide reassessment. As all of us have mentioned, a majority of our school districts in Delaware County, including those represented on this Zoom conference, have started both informal and formal measures to attempt to convince the county to take a step back and pause and reevaluate. Like Mr. Bilker very eloquently said, we are suggesting that the work has not been done properly and completely. One of the things that we've done, in addition to what Mr. Chestnut said about reaching out with direct communication, same thing that Mr. Pupio referred to, we've also initiated in front of the Board of Assessment Appeals a presentation, which we did several weeks ago, to show them all this information that we're now presenting to you tonight, including the expert testimony of our expert witness who did the assessment study. So the Board of Assessment Appeals has had this same evidence for weeks. And we are hopeful that the county, because again, we are the same taxpayers. I pay taxes to the county, to my school district, which is Garnet Valley, and to my municipality, which is Concord Township. The county is being funded by my same taxpayer dollars. As everyone has said here, there's no sense getting into needless litigation when we should all be working together. So we're doing everything we can to protect our taxpayers and protect their money, and to attempt to persuade county council to have meaningful discussions with us to correct what we strongly believe is right now an unfair and inequitable countywide tax reassessment. Thank you, Dr. Edelberg.
Thank you, panelists. I want to thank you on behalf of Delaware County Intermediate Unit for being with us this evening, as well as all of our residents within Delaware County. Thank you for fighting for us. Thank you for being our voice. And hopefully Delaware County County Council will engage in meaningful conversations to help to resolve this issue. Participants, I hope you found this of value. We have a recording and we will be sharing this out with your districts as well. Thank you for being with us tonight, and have a wonderful evening. Goodbye.